Good morning, good evening, good afternoon, depending on where you are. I don't think this is going to be a long stream. I hope this isn't going to be a long stream. I've glanced at this document, but I haven't gone over it. It appears to be just a rehash of Chili's trifold. While people are filtering in, I got this comment on my video, "Can you film in a courthouse?" Where this person, FBQ don't fold. He says filming is considered legal business under the First Amendment. Is it? I mean, cite your source. I've never once heard a court say that filming is considered legal business. I mean, obviously there's commercial photography. There's even news photography is also commercial. So it's business, but I've never heard a court describe filming just in general as a legal business under the First Amendment. He says, if you have legal business in public, you can't be trespassed from public. Well, you know what? Again, citation needed. There are situations where it is harder to get trespassed. But for example, public park, you can be trespassed from a public park, even if you have, quote, legal business, end quote, in there, especially if your, quote, legal business, end quote, is filming. He says courthouses and courtrooms are very different things. Well, not really. I mean, they are different things, yes. But for terms of whether or not a court has the power to make an order restricting photography or filming or recording in the courthouse as opposed to just the courtroom, no. The courthouse, the court has the ability to make orders governing the behavior in the courthouse. And according to US v. Grace, it is most likely a non-public forum. Most courthouses restrict filming. And hold on a minute. All right, so sorry about that. Most courthouses restrict filming in or photography that I've seen in the courthouse, not just the courtroom. Sometimes they just limit it to courtrooms, but you'll find that a lot of like federal courthouses especially will limit filming in the courthouse. I mean, except for certain situations where they might allow it. Furthermore, filming myself while conducting other lawful business is a right under the same constitutional rights that allow you to defend yourself. I don't understand what that means. I'm thinking he's believing he has a First Amendment right to do it. So great. He says, if I can't produce evidence for my litigation, how am I expected to litigate? I don't understand. Maybe he thinks that he's going to sue for something to do with his interactions with court clerks or something. I don't know. It's hard to define what he's talking about there. Hard to understand what he is envisioning. He says, you people need to spend more time creating new laws to regulate crime than you do trying to find gray areas in old laws that are already clearly defined. Do better. Well, there was a gentleman by the name of who went by Pissed Off Taxpayer. He thought he had an unrestricted right to film in a courthouse, and he filmed himself paying. He went to go pay a fine or something, and he ended up getting arrested for trespass for filming in the courthouse, despite having lawful business there. And he lost that case bad. So, I mean, your mileage may vary. I just want to make it clear that these rights that you think you have, I mean, you just think you have them. It doesn't necessarily mean they exist. So take it all with a grain of salt. But anyway, we have people in here now. So that's not why you're here. You're here for this pile of dog shit. I have, again, just glanced at it, so I'm not entirely sure of everything that's in it. The weird thing is that this document is the PDF in my browser tab says copy of, and then Cyrillic for copy. Copia. copy of copy, and then it's entitled, in quotes, brochure underscore capital A4, end quote. When can strict scrutiny apply to prohibitions against filming of government property or filming on government property? Well, that would be in a non-public forum. If you're in a place that's a non-public forum or even a limited public forum, no, I'm sorry, strict scrutiny. Strict scrutiny against filming of government property or filming on government property. So filming on government property would be most likely a forum analysis if the restriction applied to the property. And it would most likely be either a non-public forum or at best a designated public forum, usually. So when can strict scrutiny apply? When can strict scrutiny apply to prohibitions against the filming of government? Okay, so for example, what was that, 18 USC 730 whatever? 18 USC filming vital, spelling counts, vital installations. 18 USC 795. So this, the way the president, through his executive orders, has defined this, it could be things that are deemed to be vital military installations, even if they're not on government property. If, for example, a tank engine has been defined to be a vital military installation, and the tank is rolling down the street and it breaks down, and they open up the hood of the tank to repair the engine, and you take a picture of it, you could, in theory, be in violation of 18 USC 795. 18 USC 795, since it applies anywhere, everywhere, all the time for filming government property, etc., then it would be subject to strict scrutiny. So that's one example. I hope that helps. Anyway, that's not what you're here for. So this is his ultimate guide to police interactions. I'm just going to go ahead and say it's not an ultimate guide to police interactions because I have scrolled through it. And he talks about things like freedom of religion, the Third Amendment, which obviously has nothing to do with a police interaction. Hopefully the Second Amendment has nothing to do with the police interaction. Things have gone horribly wrong if police interactions are somehow involving the Second Amendment. But this, he calls it Ultimate Guide to Police Interactions, Understanding the Law and Your Rights Under the U.S. Constitution. Here's the problem that both Colin and Shelley have, is that neither one of them understands their rights under the law and the U.S. Constitution. So how can they teach what they don't understand? You can't teach what you don't understand. So it's a real problem. And again, to put this into context, my con law textbook, which is just a broad overview of the various portions of constitutional law from way back when I was in law school, was yay thick. I mean, 3 inches, 4 inches thick. I mean, it was a thick book. And it was fairly densely packed with concepts. So trying to give a broad overview of the Constitution in 6 pages over what these individual snippets mean, you're not going to be able to do it, especially since you don't understand it yourself. And then this AI police officer looks really ridiculous. He has 6 fingers on one hand. He's got this weird bloop thingy over on his left side. And what the hell happened to his feet, I don't know. But that's bad AI. So good job, Colin. So there's this long-winded introduction that I don't know if I really want to read it. It's an introduction. He has it all in quotes, and he's not quoting anybody. I did do a quick Google to find out who, if anybody, he's quoting, and I can't tell. I can't find anybody that he's quoting on it. So a lot of it's word salad. So I'm just going to skip it. I got a thing in my throat. And we'll get to the actual lesson, I guess. So he has the Bill of Rights. Bill of Rights. He starts off with the First Amendment: freedom of speech, religion, press, assembly, and petition. So freedom of speech, he says you can say what you want without the government stopping you. What that does is it ignores all of the other times where the government, in fact, can stop you. Like if you're making true threats, the government can criminalize true threats. The government can criminalize fighting words. The government can criminalize or stop you from false advertising. The government can punish you for defamation or CP. You know, some people say that's speech. I don't necessarily believe that, but you know, if pornography is speech, you know, and the government can criminalize pornography in general. So just that statement is misleading in and of itself. You can say what you want without the government stopping you. It should have a huge asterisk by it. Freedom of the press, newspapers, TV, websites, and with the advent of social media, even you filming with your camera phone can report news without government control. Well, again, this is a vastly overbroad statement. I mean, there are times, I mean, it depends on where you are and what you're doing. Can the government restrict your right to even record in public? Yes. I mean, it's subject to reasonable time, place, and manner restrictions. That's what literally every circuit that has looked at the issue has held, that your right to record government officials doing their jobs in public is subject to reasonable time, place, and manner restrictions. Freedom of religion, you could practice any religion you want or not practice any religion at all. Yeah, but even the freedom of religion, there are restrictions on your freedom of religion. If your religion requires you to do some sacrifices of animals, a law that prevents cruelty to animals might prevent you from practicing that particular portion of your religion. So none of these are, you know, without a caveat, without an asterisk. You can gather peacefully with other people. Sure. You can ask the government to change things you don't like. Sure. I mean, those are very general phrases, but yeah, sure. I don't have any real issue with those. Second Amendment, you have the right to own guns for your protection or for sports like hunting. You have the right to own firearms, period. The why isn't really important. You have the right to own firearms and other weapons, period. I mean, unfortunately, right now, the government can restrict some of the firearms or other weapons you can own, but Third Amendment. Why are we talking about the Third Amendment? And here's a fun fact. The federal government can't force you to let soldiers stay in your home without your permission. That's the Third Amendment. But the Third Amendment hasn't been incorporated through the 14th Amendment to apply to states. So in theory, a state militia, the governor can, in theory, at this point, still say that you have to quarter the state militia in your home because the Third Amendment doesn't apply to the states. There's what's called the incorporation doctrine. And for example, there are some amendments that are fully incorporated, like the First Amendment, fully incorporated, and the Fourth Amendment's fully incorporated. I think the Second Amendment is fully incorporated. I could be wrong. And the cruel and unusual punishment, Eighth Amendment, is fully incorporated. And then you've got a couple amendments that aren't. I know the third isn't. I think it's the Seventh Amendment. It's got to be the Seventh Amendment because the Fifth and the Sixth are partially incorporated. So it's first, second, third is not, fourth is, fifth is partial, sixth is partial. So it's got to be the Seventh Amendment. And I'll be honest with you, I don't even remember what the Seventh Amendment is right now. So I guess I need to go back to school. So the Third Amendment doesn't apply to the states. This is really what I'm trying to say. And then he has the Fifth Amendment. Here are the rights of the accused. Now, the Fifth Amendment covers a lot of rights, not just the rights of the accused. He says you have the right to remain silent. Sure, with an asterisk by it, because So the thing is that you have the right to not be forced to be a witness against yourself. So you have the right to remain silent as a Miranda right, but you have the right not to be forced to be a witness against yourself. Now, your Miranda rights are a due process portion of the Fifth Amendment, not the actual right to not be a witness against yourself. And anyway, these are complicated concepts, I guess. Okay, so he says you can't be tried for the same crime twice. That's double jeopardy, I'm assuming. But when does that apply? Certainly, you're not looking at double jeopardy when you're being stopped by the police. That's not part of a police interaction. But when does double jeopardy apply? Well, hopefully you have an attorney by the time you're facing double jeopardy or even single jeopardy. You can't be forced to testify against yourself. That is self-incrimination. So he has it in there. But this is part of the due process. You have the right to remain silent. That's part of due process. You can't be forced to testify against yourself. That's self-incrimination, sure. But then he has due process again. Apparently, you have the right to due process. I mean, the government has to follow rules when it accuses you of a crime, and your property can't be taken without fair compensation, I believe is what he means to say there. Or due compensation, I think is actually what it's called, but he says fair. So I'm going to guess fair compensation. He doesn't include your right to grand jury indictment in there. I mean, that's a pretty important one, I think. And yeah. And I'm not actually entirely sure that that this due process right, that might be 14th Amendment due process issue for Miranda. I might be wrong on that, but that's a due process issue. Sixth Amendment. The Sixth Amendment is only partially incorporated, and there's a lot to the Sixth Amendment, so this isn't all of it. You have the right to a speedy and public trial. Yes, you have the right to a speedy trial. That's a different thing than the right to a public trial, which you also have. Both of those have been incorporated. You have the right to know what you're accused of. You have the right to know what you're accused of. Okay, that's notice of accusations, I guess, is what they're saying. They have to arraign you to make sure that you know what you're accused of. You have the right to an attorney specifically in criminal matters, and that only attaches if you are facing 6 months or more in jail. More than 6 months in jail? I think it's more than 6 months in jail. That's where the right to hold on a second. The right to an attorney is any jail time. The right to a jury is 6 months or more in jail. That's right. So if you're facing the potential of any jail time, then you have. Hold on a second. It's weird. Let me think about this for a minute. I probably should have done a little bit of homework before I started this up. I think if you're sentenced to any jail time, then you had the retroactive right to an attorney, which is weird, I know, but I believe that's the way it works. And then if you are facing a potential of 6 months or more in jail, then you have the right to a jury or something along those lines. Again, it's just more complicated than what he has here. You have the right to confront witnesses against you. Yes, you also have the right to call witnesses for you. You have the right to confront not just hostile witnesses, but you have the right to confront favorable witnesses, and you have the right to subpoena witnesses, to force witnesses to appear. So the right to confront witnesses, you have the right to confront witnesses against you and for you, and you have the right to call witnesses to support you. You have the right to subpoena witnesses. Seventh Amendment up here. You have the right to jury trial in civil cases involving money or property. Again, the Seventh Amendment does not apply to the states. So So you gotta take that one with a huge asterisk by it. And then the Eighth Amendment, no cruel and unusual punishment. Punishments can't be too harsh for the crime. Bail fines can't be excessive. Well, oh, he says bail or fines. I'm sorry. I thought he said bail fines can't be excessive. Bail or fines. Yeah. So it's three. There's three portions of it. It's excessive punishment, cruel and unusual, I should say, and then excessive fines or excessive bail. Ninth Amendment. This isn't like really a thing. I don't know. Well, I mean, it is a thing, but like, how would that even apply? How would the 10th Amendment? I mean, these aren't things that you're going to invoke during a police encounter. Anyway, these amendments outline important rights and protections for individuals against government overreach and injustice, but he doesn't put in the 14th Amendment. Obviously, it's not part of the Bill of Rights. But the 14th Amendment is a crucial amendment simply because it is what makes some of the Bill of Rights apply to the states, and it has its own provisions in it. Nobody sues under the 5th. Well, you could, in theory, sue under a 1983 cause of action for violation of your 5th Amendment rights. So anyway, that's where we are there. Landmark cases that uphold our rights. Right to record police, Glick versus Cuniff. Sure. I mean, that's First Circuit. I believe Glick is First Circuit. If I had to bet money on it, I would say Glick is First Circuit, which means it only applies to a very small fraction of the entire United States, especially if you're looking by landmass. I think the First Circuit is like Connecticut, Massachusetts. I mean, it doesn't even have, I think the Second Circuit is New York, so it doesn't even have like New York in it. First Circuit's a very small swath of land. From the First Amendment right to record, police officers performing their duties in public places as long as the recording does not interfere with legitimate law enforcement activities. Well, it is specifically subject to reasonable time, place, and manner restrictions. Specifically subject to reasonable time, place, and manner restrictions. Every court of appeals, I should say, that's addressed the issue has said it's subject to reasonable time, place, and manner restrictions, which means you don't have an unrestricted right. So, I mean, how is a person reading this going to know that it's subject to reasonable time, place, and manner restrictions? No ID without reasonable suspicion. Brown versus Texas. Brown versus Texas, there was a Texas law that allowed police officers to demand your ID, just to demand your ID. And the Supreme Court says, no, you can't do that. And then because it has to be, it's a seizure, and that has to be based on at least reasonable suspicion or probable cause. But then it was Hibble that said, as long as the state has reasonable suspicion for their stop and ID law as the basis for the stop and ID law, then they're good to go. But see, here's the thing, though. He says lawful stop. If it's a lawful stop, a stop would be a seizure in some form or fashion. So if it's a lawful stop, then they would have to have reason. So he's saying like they can't arrest you for refusing to provide identification during a stop for which they have reasonable suspicion or probable cause, unless they have a reasonable suspicion or probable cause. Okay. But again, they can't arrest you unless what you're doing has been criminalized in the first place. So there's no general right of the police to arrest you for failing to provide identification. There has to be a state statute in place that says that the police can demand your identification if they have stopped you for at least reasonable suspicion, and that allows them to arrest you for failing to provide the ID. Just a statute authorizing them to make the demand doesn't give them the authority to make an arrest. There has to be another statute that criminalizes it such that they can make an arrest for it. Passengers can challenge the stop. Brendlin versus California, 2007, determined the passengers of the vehicle stopped by police are seized for the Fourth Amendment purposes and therefore have standing to challenge the legality of the stop. Absolutely. Absolutely. In order to search, cops must gain consent from all occupants. From all occupants. Georgia v. Randolph did not deal with occupants. Georgia v. Randolph was where that wasn't the overnight guests. That was there was one Supreme Court case where overnight guests had a Fourth Amendment right against searches without warrants. And there was one that says that co-tenants, I think Georgia v. Randolph was one where co-tenants, like, so if you have a roommate and your roommate consents, says, yeah, please, you can come in and search, and you say, no, you can't, then the police don't have consent to search. They have to get consent from all the tenants who are there. There is another case, though, that says if you're not there and your tenant okays the search, then the police can come in and search, even though if you were there, you would say no. So, but occupants, I mean, it does that. Just because someone's in your home doesn't mean that they can revoke consent for the search, for the entry and search of the home. So this is incorrect wording. This is wrong. In this case, the United States Supreme Court held that when two occupants, I'm sure it's tenants. Let me look this up. Georgia versus Randolph. Georgia versus Randolph. Oh, hold on a second. There we go. I guess they do. It has to be an occupant who shares or is reasonably to share common authority over the property, and no present co-tenant objects. I don't know why they're switching around their words. I learned it as co-tenants. So I guess maybe with that it could be occupant. So mea culpa. But again, this, when they're talking about occupants, they're talking about co-tenants. They say co-occupants, but co-tenants is really what they're talking about. Not just that you're there occupying the house, but like you're there not just overnight, but you're a tenant. The Fourth Amendment prohibits a warrantless search of a shared premises. Yes, sure. The court reasoned that a physically present co-occupant's refusal to permit entry renders a warrantless search unreasonable and invalid as to them. This decision reinforces the principle that consent to search must be given voluntarily and can be revoked by any party who shares authority over the premises. Well, so my concern here is that doesn't necessarily apply in like traffic stop situations where you'd be much more likely. Oh shit, you're not seeing what I'm seeing. So in a traffic stop situation, the driver can give consent to search the vehicle, and I'm not aware of any restriction that says that the passenger can revoke consent. And in Texas, I know because I've had to look this up before. In Texas, I am aware that even if the owner of the vehicle is a tenant, the driver of the vehicle can still give consent to search over the objection of the owner who's a passenger. So the driver in Texas specifically was like a 2013 case. I forget the name of it. But in Texas specifically, and other states might hold different things. So there's no, as far as I'm aware, there's no Supreme Court holding on that matter. So just take it all with a grain of salt. Cops cannot extend stop to get a canine. Well, that's true. Rodriguez versus U.S. Remember that Chile handles this entirely wrong. The cops, so in Rodriguez, again, the officer made the stop. He had probable cause for the stop. He issued the ticket. When he was done with the ticket, he then made the person stay, the person who he had pulled over. And the court held that, when you've resolved the issue that gave you probable cause, you no longer have the right to keep them seized. So you got to let them go. You can't extend it. Oh, one of the premises in all of this mishmash, by the way, So by presenting legal statutes and precedents in tangible form, this guy not only facilitates individual assertion of rights, but also serves to remind law enforcement officers of their obligations under the law. I have never once seen someone shouting about these various things to a cop and having the cop be like, you know what, you're right, I'm just going to go ahead and do a thing. It doesn't work that way. In Rodriguez versus United States, Supreme Court ruled that police officers cannot prolong a routine traffic stop beyond its initial purpose without reasonable suspicion or consent. Yes. So like if when the cop is giving you the ticket, and again, you won't know these things, right? You won't know these things as the person sitting in the car. That if the cop is giving you the ticket while he's at your window, he smells the marijuanas. Now he has reasonable suspicion that there is the marijuanas in the car, and he can delay the stop for the dog to come to sniff for the marijuanas. And if you have 5 marijuanas in the car, then you could, in theory, not suppress it because the cop smelled the marijuanas. And you won't know this. I mean, he doesn't have to tell you that he smells the marijuanas. He probably will, but he doesn't have to. Cops don't have to tell you if they smell the marijuanas. Denny's Rodriguez was stopped for a traffic violation, and after the officer issued a warning ticket, he detained Rodriguez to conduct a dog sniff for drugs without reasonable suspicion. Yep, that's the problem. He no longer had reasonable suspicion to detain Mr. Rodriguez. Rodriguez objected, but the dog alerted drugs, leading to his arrest. The court held that detaining the stop without reasonable suspicion or consent violated the Fourth Amendment's protection against unreasonable searches and seizures. The petition reaffirmed the traffic stop must be reasonably related to its initial purpose, preventing officers from unreasonably prolonging stops for unrelated investigations. Well, again, no, because yes, but no. Because like I said, if the officer develops reasonable suspicion of some other crime while he has you stopped, he doesn't have to ignore it. He can then proceed to investigate the new thing. Like he's walking up to your car to issue you the citation. He hears a pounding, a knocking from inside the trunk of your car, and someone screaming, help, help, I'm being kidnapped. He doesn't have to be like, you know what? I really would like to delay this traffic stop to investigate to see if you are in fact kidnapping someone, to see if you have someone trapped in the trunk of your car. But I can't do it, because of Rodriguez. Darn Rodriguez. I mean, it doesn't work that way. All right. Right to revoke consent. U.S. versus Williams, United States versus Williams, United States Court of Appeals for Third Circuit addressed the issue of consent to a police search. The police held that the person has the authority to give consent to a search. They also have the authority to revoke that consent. They do. So some caveats, though. You can limit what you allow search of. If a cop says, I like permission to search your car, you can say, yeah, I'll let you search the passenger compartment, but not the trunk. You could do that. You could limit what the search for, right? You could also revoke your consent. However, the revocation of consent may not make any subsequent search unconstitutional because, again, if they have a vehicle search, reasonable suspicion or probable cause, or one of the other rationales for the search that support the search, they may not need consent. They may have already developed some other justification for the search that renders the search constitutional by the time you revoke. So just a caveat, obstruction is a physical act. California versus Casey. California, the United States Supreme Court held that to establish the offense of obstructing a police officer, there must be evidence of an actual physical act or interference with the officer's duties. Mere verbal opposition or non-cooperation without any physical obstruction do not rise to the level of obstruction of justice. This decision underscores a principle that the obstruction of police typically requires more than mere words or passive resistance. From 1976? Why have I never heard of this case? California versus Casey. Search. California versus Casey. Well, that's a problem. That's a problem. Hold on a second. Let's go to California site. Decidable cases. And we're going to go to California versus Casey here to see what got us to. It's got to be sort of state case. So California v. Casey. It's a California case. Chance tab instead. Nothing. Oop, I had a 4 there. Hold on a second. Doop. Search. All right. What happened? What happened? Share, present, share screen. Results for California versus Casey. Share, nothing. All right. So that's a problem. This is a problem. If you're citing a case that doesn't exist for a proposition that isn't true, then that's a problem. That's a real problem. You might not want to listen to someone who makes up case law. Just saying. Smell of alcohol. Smell of alcohol is not considered probable cause. People versus Cruz, 1993. People versus Cruz. No, there's no alcohol in it. It's a restitution case. People versus Cruz. Alcohol. Oops. Alcohol. Quotes around that as well. And let's do. This is published in 2008. Is this another one? 2019. How about this? How about let's put this in quotes. We'll get there. We'll get there, folks. It's a California case. I know that because I know SoCal, Stanford versus Cruz. It's 2008.
What?
Here we go. People versus Cruz. That's not to be published. I already looked at this one. It's a 1979 case. I'm going to go ahead and say that this is another one that doesn't exist. In this case, the New York. Oh, did I look at New York? New York. No. Oh, actually, let's look at it just in case. See what it is. No, that's not it. So I'm going to say that that is probably another case that doesn't exist. Smell of marijuana is not considered probable cause. We've covered this one. This is a Chileism. This is Pennsylvania Supreme Court. It says that since marijuana is not a state, it's not a state crime to have marijuana necessarily. It can't be probable cause by itself. Stop and frisk. Terry, stop. Stop and frisk doctrine. Police officers to conduct a limited pat-down search of a person's outer clothing if they have reasonable suspicion the person is armed and dangerous. They're permitted to frisk the outer clothing. Did I read that twice? No, he has it in there twice. To search for weapons that may pose a threat to officer safety. It's limited to what is necessary to discover weapons. It does not extend to a full search of the person's pockets or belongings. It's hard to read this, but he says it's important to note that the legality of the search is based on the smell of alcohol and marijuana can vary depending on state laws. Yeah. So why are you putting it in here? This is understanding the law and your rights under the U.S. Constitution. So, I mean, it's a good question, huh? In some jurisdictions, court have ruled that the smell alone may constitute probable cause for a search. Most you generally speaking, if the officers smell alcohol on your breath, they can do DUI stuff. I would say, generally speaking, just expect that. While in others, additional evidence may be required. Therefore, it is advisable to consult relevant state laws and appellate court decisions for specific guidance on the issue in a particular jurisdiction. How about this? How about instead of doing that, how about you talk to a local attorney? What to do when you get pulled over by the police? When you get pulled over by the police, it's important to remain calm and follow these steps. Pull over safely. Find a safe spot to pull over as soon as you can. Use your turn signal to indicate to the officer that you're complying. Sure. Start recording. It's important to get your own video evidence of the interaction because not all agencies have body cams or dash cams. And although there are FOIA laws, it's extremely difficult to obtain body cam or dash cam footage of the police. Well, like if you were speeding and you know you're speeding and you know the cop's just going to give you a ticket for speeding, like, why do you need to start recording? Like, why do you need to start recording? Just fucking, why? Just, why is it important to get your own video evidence of the interaction? Roll down your windows. If at all possible, roll your windows down at least halfway to make it easier for both the officer and you to have a conversation. Well, I mean, talk to a local attorney. If you've been drinking, maybe not. Maybe keep your window up all the way if you have any alcohol on your breath. Stay in the vehicle. Keep your hands visible, preferably on the steering wheel. Wait for the officer to approach your vehicle. Avoid making sudden movements. That's pretty safe, but I don't necessarily stay in the vehicle. I mean, stay in the vehicle unless you're ordered out of the vehicle. How about that? Don't remove your seatbelt. Leave your seatbelt on until the officer comes to your window to see and can see you take it off. You don't want to give the officer probable cause to write another ticket against you. Sure. Be respectful and cooperative. Greet the officer politely and follow their instructions. I don't know about you have to greet them politely. It doesn't hurt to be polite, but I don't know. Provide your driver's license, vehicle registration, proof of insurance when asked. Remain calm and avoid arguing or being confrontational. It's probably good. You're less likely to get a ticket if you do that. So that's fine advice. I don't know if you have to greet the officer politely. I don't know. Listen carefully. Pay attention to what the officer says and follow their instructions. They'll likely explain the reason for pulling you over. They probably will. They might ask you questions. If they ask you questions, say, I don't answer questions. Do you know why I pulled you over? I don't answer questions. It sets the tone. Their next question will be, you don't answer questions? To which you respond, I don't answer questions. Know your rights. You have the right to remain silent and not incriminate yourself. If the officer asks questions, you can choose to politely decline to answer without being rude. Well, so again, more information is necessary because if you have been answering questions and then you suddenly stop answering questions when the cop asks an incriminating questions, the police can infer that your sudden silence is they can use that against you. So if you have been answering questions and you decide to stop answering questions, at that point, immediately invoke your Fifth Amendment. But it's always best to not answer questions in the first place. Don't get them going. You don't know what could or what may or may not be incriminating. So just don't answer questions. Do not consent to search. That's good. Never consent to search. You have the right to refuse to consent to a search of your vehicle or person unless the officer has probable cause or a warrant. Clearly and calmly state that you do not consent to any searches. That is excellent. That's excellent advice right there. Don't consent to any searches. And I say this because you don't know if you've ever had anyone in your car other than you. Maybe they dropped a doobie. You don't know. There might be a doobie in your car that you're not aware of, or they might have dropped a pill that you're not aware of. It is always better just to say, no, I don't consent to any searches. I'm not even saying that you would be necessarily, of a guilty mind. It might not be your doobie. It might not be your pill, but it might have fallen out of somebody else's pocket on accident. And all of a sudden, you're catching a charge. So just refuse the search. Follow traffic laws. If you receive a ticket, sign it. This is not an admission of guilt, but a promise to appear in court. You can contest the ticket later in court if you choose. Yes. Document the encounter. If you feel your rights were violated or the encounter was not handled properly, make a note of the officer's badge number, patrol car number, and any other relevant details. You can also consider filing a complaint with the police department. Sure. Good luck with that. Do not argue with the police. Well, it's counterproductive to argue with the police, so I would say yes, generally speaking. In light of the precedent set by the Supreme Court case Terry v. Ohio, it's crucial to prioritize officer safety during traffic stops. Well, you don't have to prioritize their safety. They may prioritize their safety, but you don't have to. The primary objective for both the officer and the individual being pulled over is to ensure a safe encounter, allowing everyone to return home unharmed. Consequently, it's imperative to refrain from engaging in arguments or disputes on the side of the road with law enforcement officers. It is counterproductive to engage in them unless you're monetizing the videos on your channel, in which case, have fun. Even if you believe an officer's directives to be unlawful, disputing them in the moment can escalate tensions and compromise safety. Instead, comply with all lawful instructions. Wait, even if you think they're unlawful, comply with all lawful instructions. Well, how about you just comply with the instructions, whether they're lawful or unlawful, and then sue them later and reserve any concerns about rights violations for a more appropriate venue, such as addressing in the court. By choosing not to argue roadside, you promote a safer outcome for all parties involved. Yes, you do have to remember that when you're arguing with a cop, you're arguing with someone who is armed and armored, and you're probably not. If you feel your rights have been violated, here are some resources that you can contact for help. Okay. And that's it. Entirely stupid. I'm not thrilled with it, especially since he threw in case law. Merb doesn't understand being other than white in America. But you know what I do understand? That I never want to hear from you again. I don't need your kind of race baiting in my comment section. Thank you very much and have a great day. I hope you enjoy your life. So anyway, that was it. When there be thousands of California versus Cruz, it was people versus Cruz. It was people versus Cruz. And he says it's a New York Court of Appeals decision, but I searched for New York. I was in my search terms. So I assume there would be thousands of people versus Cruz. I mean, there's a large, was it Puerto Rican and Dominican population in New York. I distinguish that there are multiple cases that have controlling authority that happen to have the same name. Well, normally what you do is you actually provide the full citation. So for example, this is Georgia versus Randolph, but you see then there's this right here. That shows the publication that it was made in, which is US, the volume of the publication, which is 547, and then the page number in the volume that the cited opinion appears, which is page 103. If you're citing to a specific portion of it, then you'd put a comma, and then you would put the page number in the opinion where it appears. So maybe like Georgia versus Randolph, 547 US 103, comma 108 to 110. That's the way you would normally handle something like that. Anyway, that's all I got for you today. Thanks for watching. Have a great day.